Hey, estate planning attorney Paul Ravelli here, and in this video we're going to talk about 9, yeah, count them, 9 living trust mistakes. Okay, here's the background. It seems like if there's one most popular, most talked about topic or item when it comes to estate planning, it's the one that estate planning lawyers get a lot of questions about. It's the one where lots of articles are written about this. It's the one where lots of books are written about it. And quite frankly, it's the topic where lots of videos are made and consumed. It's the whole concept of using the revocable living trust to avoid probate, or as we call it in Louisiana, succession, when somebody passes away. And I kind of feel like the reason it gets so much attention is because I think not just the wealthy, not the people with just the people with the large estates, but the middle class. What appeals to them is that ability to make their estate settlement simpler for their survivors by eliminating the need for all of the court and lawyer involvement that's required when you pass away with assets in your name, and we have to get lawyers and judges involved and get court orders in order to get those assets transferred. So a lot of appeal to it, but like anything else in life, if you're going to do something, you need to do it right. And so mistakes get made, and when mistakes get made, things don't happen as they were intended. So I'm going to give you 9 mistakes that people make when they establish living trust. So maybe if you take advantage of that opportunity to avoid all the court and attorney involvement in your estate settlement, maybe you won't make any of these 9 mistakes. The first mistake, it's the one in any list of living trust mistakes. This is always on the list. It's the failing to what we call fund the living trust. I'm going to link you to a video right up there. It's called If You Have a Living Trust, Watch This Now. It's the most watched video that I've made of something like 500 videos, and it'll give you a good idea of what it means to fund a living trust. But essentially, not only is it important that you create your trust, but it's also important that you transfer your home and other investments and other assets that would have to go through the court process when you die. It's important to get those transferred to your trust so they won't be frozen, and your trustee, perhaps a family member, can then distribute those assets from your trust after you pass away without the court and attorney involvement. So failing to fund the trust is mistake number 1. Mistake number 2 is the trust is poorly written. This trust instrument is going to control what's going to happen to what you have, not only for the rest of your lifetime, but even more importantly, what happens when you pass away and beyond. So it needs to be worded properly. When you think of having heirs, if you have a trust, they're called trust beneficiaries. And when you list your beneficiaries, you will list income beneficiaries and principal beneficiaries. You need to get all of that right. If you're a married couple setting up a trust together, you've got to really nail the what happens when the first spouse dies to make sure there's no conflict at that point. Also in your trust, you'll be making lots of trustee and successor trustee appointments. You'll be designating trustee powers, trustee duties. So you want to make sure it's well written. Things are much more likely to go smoothly if it's well written. Mistake number 3 is thinking that your revocable living trust assets somehow protect you in case you go to a nursing home. So a lot of middle-class people out there, they are worried that if they go to a nursing home, they're going to have to spend their life savings and sell their rental property and go through their IRAs, spending them at the clip of about $6,000 to $10,000 a month. And they'll have to consume all of that until they get down to less than $2,000, and then long-term care Medicaid kicks in and pays that nursing home expense. Well, some people mistakenly believe that if they transfer their assets out of their name into their revocable living trust, then hey, those assets aren't in their name anymore and they're protected from nursing home expenses, but that's not correct. So because a revocable living trust enables you to change the trust, undo the trust, remove the assets from the trust, and put them back in your name, because you have so much control over those trust assets. The Medicaid rules say, sorry, but since you have so much control over those assets, you've got to exercise that control if you go in a nursing home, and you've got to consume all of those assets before Medicaid will pay for the nursing home. Mistake number 4, similar, Thinking that your revocable living trust assets protect you from liabilities or creditors. So a lot of people out there, they've set up living trusts, but along the way, they've incurred significant credit card debt. Some people, not only 5 figures, 6 figures of credit card debt. Many people who have trusts when they've done business over the years, they've signed certain personal guarantees, so they're personally responsible for business debts that sometimes get out of control. So real important that you realize that moving your assets into a living trust or a revocable living trust doesn't give you any creditor protection. So be aware of that. Mistake number 5 is not having the other ancillary documents in addition to your trust instrument. So that trust instrument can't stand by itself as a comprehensive, estate program. You have to have all the ancillary stuff. For example, everybody who sets up a trust also establishes their power of attorney or durable power of attorney. Now, sure, if your home and other assets are titled in the name of your trust and you become incapacitated, then that successor trustee that you named in your trust instrument can transact all of those trust assets for you. But you're likely not only to have assets in your trust, but you're also likely to have assets still in your name, such as a traditional IRA or a Roth IRA. Those don't get transferred to your trust. So you need to have that durable power of attorney in place so that your agent can then transact those assets that are in your name. And then that person may be the same person as the successor trustee of your trust who would transact trust assets when you become incapacitated. And then there's all the healthcare power of attorney who you'd want having access to your medical records. I'll post a video about one of the living will videos that I made about life support machine decisions. And then, I'll also point you to another pour over will video, which everyone who sets up a living trust, they create this pour over will, just another term for a last will and testament. But with the pour over will, it usually says something like, and I'm being the layman's term here, it might say, if I die with something in my name that's not in my trust, I want it transferred to my trust when I die, but your survivors will have to go through the probate process to get those assets transferred to your trust when you die, hence the importance of funding your trust. Mistake number 6 is realizing that your living trust doesn't control where your IRAs, life insurance, and annuities go when you die. Those assets are controlled by your beneficiary designation. Let me give an example of how that could be a real problem. Let's say Grandpa comes into the lawyer's office to do his trust. He has a $3 million estate, and he has thought for years, he's always told his grandchildren, you know what, I have 10 grandchildren. I love my grandchildren. Guess what, guys? When I die, I'm going to give each of you $100,000. That'll be that $1 million that'll come off the top. My other 3 kids can split the remaining $2 million. I have a $3 million estate. Grandkids get excited. Grandpa, that's so nice of you. That'll enable me to make a down payment on my house or buy a car or go to college or go to law school or medical school. Everybody's all excited. Grandpa goes in and sets up his trust. He tells the lawyer, yeah, I want to draft my trust, so $100,000 goes to each of my 10 grandchildren. The rest can go to my 3 children. Lawyer writes it up that way. That's great. He transfers his house to his trust. He transfers some other financial accounts to his trust. But the bulk of Grandpa's money is in his IRAs. So his house is worth $300,000. The other financial accounts that he put in the trust are worth about $50,000. But his IRA is worth $2.5 million, and that doesn't go in his trust. Grandpa dies. There's only $350,000 of assets there to fund the 10 $100,000 transfers that Grandpa directed in his trust. So guess what? Those grandchildren aren't going to get $100,000. At most, they'll get $35,000 apiece, because there wasn't enough assets in the trust to fund those bequests, because Grandpa had named, when he set up his IRAs, he simply named his 3 kids as his beneficiaries. They're going to get all of that money. So realizing there needs to be some coordination between your will, your trust, and your beneficiary designation items, that's a big mistake. Mistake number 7 is along the same lines, naming your trust, your living trust, as the beneficiary of your IRA when you don't need to. So sometimes dad will come in. He says, I want to keep things simple. I've got 3 adult children. They're all adults. They're all responsible. They all get along great. When I die, they can handle the money. They can do whatever they want to. They're better at managing money than I am. So really, and dad creates his trust to put in his house and all those probate assets. And he asks whether he should name his trust as the beneficiary of his IRA. And perhaps in those circumstances, I might tell him, you know what, Dad, just name your 3 children as, you know, each getting 1/3 of your IRA when you die. That way, when you die, the kids can bring a death certificate to your IRA financial institution. The financial institution will set up 3 new inherited IRA accounts. They'll move the money from your IRA into the 3 equal inherited IRA accounts. That'll be done with. Instead of routing the IRA through the trust, then back to the kids. You see, when somebody dies, now everybody's got to have their say-so. You've got 3 kids at the table. You probably have a lawyer, an accountant, a financial advisor. The simpler you can make it, the simpler, you know, the better it is. So now, if you have children with special needs, children who can't handle money, it may be appropriate to name a trust or even your living trust as the beneficiary of your IRA. But you know, there's many circumstances where you don't need to name a trust as a beneficiary of an IRA. Mistake number 8 is failing to update your living trust. Most people assume that they have to update their living trust all of the time. In fact, I'm going to link you to a video, great video that I made that talks about when you don't need to amend your trust. However, you do need to update your trust when you, for example, change your mind about how you want your trust assets dispersed when you pass away, or if you want to change who that trustee will be when you pass away, who will be in charge of dispersing those trust assets. Those are common and typical examples of times when it is important that you update your trust. And then maybe the biggest mistake that people mistake, I saved it for the last, mistake number 9, gigantic mistake, it's failing to subscribe to this YouTube channel and punch and hit the notification bell. That way you won't miss anything. You're probably going to live another maybe several decades. How dare you miss out on some of this information? Make sure you don't make mistake number 9. Go ahead and, if you haven't already, hit the subscribe button and the notification bell and obliterate the like button. That way YouTube even sends my videos to more people, and we all thank you for that. All right, so there you have it, 9 mistakes when people set up living trusts. We'll see you next time.